This is a lecture from OpenTuition. To benefit from the lecture, you should download the free lecture notes from opentuition.com.
Okay, we're still on partnership, and this is the third part of partnership, international partnerships. Now, I find this a difficult area, and I find it difficult because it's not a typical F4 question, neither for 1 nor for 2 marks, but it's within your syllabus and it's only brief, and I don't have a lot to add, quite honestly, other than what's in the notes. So this next bit may appear to be just me reading the notes, but I'll talk a bit as well. But there is, right at the end of this chapter, there is a section where I do look at the difference between partnerships and limited companies. So hang on, just be brave and hang on for not very many minutes before we get to the rest of the lecture, the end of partnership. International partnerships. So French law doesn't recognise partnerships. Okay, but we do look to determine whether a person or group is acting for commerce, and if we're acting for commerce, then it's like a partnership. It's the equivalent of it. If it's acting for commerce as a fact, the affected people are required to maintain proper records and record their particulars in a commercial register. If they're acting in commerce, then they shall record that fact. And where 2 people are involved in acting for commerce, they're known as a société. There's an accent, that E there should have an accent. And in fact, it's throughout, isn't it? Where they are acting in commerce, they're known as a société, and société is therefore the French equivalent. It may be société en nom collectif or société en commandite simple. So that's how you have it. That's the French version. En nom collectif is similar to traditional partnership. Simple is similar to a limited partnership, and that one or more has limited liability. Now, I'm not doing German, I'm not doing American, I'm not doing basically because I honestly don't think it's worth the effort. If you want to look it up, fine. If you want to look in a study text, fine. I've no doubt BPP, Kaplan, Beck have no doubt that they will be pursuing at length the possibility of other international partnerships. But in my opinion, it isn't worth it. We're still on international. We do look at Muslim law. And those of you that follow Islam, of Muslim persuasion, I do hope that you will forgive my pathetic attempts at pronouncing a number of words on this next page. Anyway, here we go. Do bear with me. Muslim law recognizes 3 types of profit-sharing operations. We have musharaka, mudaraba, and shaka al-inam. Anyone here? Would you have recognized those if they weren't written down in front of you? Musharaka is very similar to traditional. Participants pool resources to invest in a commercial venture. Decision-taking shared, profits and losses are shared. Mudaraba is similar to UK partnership, where one or more of the partners takes no active part. So we're looking like a limited partnership, or a traditional partnership with a dormant or a sleeping partner. They invest in the firm and they share in the firm's profits. The investment itself does not bear interest. Again, bear with me. I have no personal experience of this, but Muslim law prevents interest from being charged on loans. But a return by way of profit is not forbidden. So, may I assume that under Mudaraba, where a person invests in a venture for a share of profits, would I be right in saying that that share of profits is increased when calculating the share? is increased to compensate for the interest foregone? I don't know. But anyway, that's what mudaraba is. Somebody contributes by way of contribution, hoping to get a return on that contribution, but not interest on their share of profits. Shika al-Ainan has the appearance of a traditional partnership. Participants invest money or other value and they share profits, but the partners are not liable for the debts of the other partners. Individual partners are responsible for the debts that they incur. And they can only sue on contracts that they themselves have entered into. So participants, although it's like a traditional partnership, where we do share profits, liability is not joint and several. So only the contracting partner can sue, and only the contracting partner can be sued under that contract. And that's all I'm saying on international partnerships. But now we come to now it comes to this, which, well, it says learn fast rats. As you are aware, I do like mnemonics, but learn fast rats is a 13-point mnemonic. To you, I don't see it ever being asked. You'll never be asked a 13-mark question anyway. But you may be asked where you could apply these elements of the differences between partnerships and limited companies. You may be able to apply them in a 1 or a 2-mark multiple choice question. Now what's happened? You see, I've lost this. I don't know how that happens. This is where it starts and goes down. That's formality repeated. So just have to make adjustment. Liability for partners, usually unlimited. Of course, if you're in a limited partnership, then liability is limited to the general partners. They are unlimited. But in a limited partnership or in a limited liability partnership, which we came across in the previous lecture, then you can have partners with limited liability. Usually limited, remember, members of companies, usually limited liability. It is potentially the case that a member will lose that advantage by being involved in irregular activities with the company, in which case the member will lose the advantage of having limited liability. But otherwise, members have limited liability. You could have an unlimited company where the members have unlimited liability, but they are unusual. Existence. No separate legal existence. It doesn't exist. A partnership does not exist as a separate person, whereas companies do. Even unlimited companies are separate people. Accounts. No requirement to file accounts with the government. You're required as a partnership to file accounts with Her Majesty's Revenue and Customs, the tax authorities, but not with the government, not with the Registrar of Companies. You are if you're a limited liability partnership. You're required to file accounts with the Registrar of Companies, who is also the Registrar of Limited Liability Partnerships. If you're a limited partnership under the 1907 Act, you again have to communicate with the Registrar, but you do not have to file accounts. The Registrar has to issue you with a certificate to identify who are the limited partners. And the limited partnership is a limited partnership under the 1907 Act. But you don't have to file financial statements. Whereas we do, as companies, even little companies have to file financial statements. Raising capital. Partners raise capital amongst themselves or invite somebody new to join them and pay in some capital. But otherwise, it's an informal matter. They can't secure debts by way of floating charge. This is a different point. Raising capital, let me go back to the first point. I'll come back to that second one. Raising capital is done internally. The firm have a partners meeting and say, we're running short of cash. Can anyone introduce more capital? Or shall we invite Peter to come and join us and introduce some capital into the firm? So it's informal in that respect. they can't raise capital by way of floating charge. Floating charges and fixed charges we'll come to when we look at company law, the law of corporations. But a floating charge is available for limited companies. Even private limited companies can pledge their debts, can secure their loans by way of pledging their assets by way of floating charge. Remember, a partnership is just you and me and two other people and another one, and it's just individuals joining together. It's a collection of individuals, the relationship that subsists between two or more individuals carrying on business in common with a view to profit. So it has no separate legal existence. And I, as a person, am not able to secure my debts by way of floating charge. I can by way of fixed charge. That's why I have borrowed money in order to buy my house, because the lender who lent me the money to buy the house now has a fixed charge over the house. So in the event of me going bust, they will have the house. Normally partnerships are limited to 20, not accountants, not solicitors, lawyers, not members of a stock exchange, and a number of others, like estate agents and estate managers, so long as at least 3/4 of their partners are members of an appropriate professional organisation. But accountants and solicitors and stock exchange members, they have unlimited. That's why PricewaterhouseCoopers has got 12,000 partners worldwide. Formality. Firm may be created, a partnership may be created by informal agreement. There's no need for formalities, there's no need for written agreements. But a company has to have formal documentation, has to have a constitution, a written constitution, has to have share capital in writing. So companies have to have these formalities, and public companies, have to be audited, but partnerships don't. So formalities is another one. Oh dear. Let me see what's the next one after formality. You've probably got it on your notes, but I don't. Assets. The assets. Assets of a company. The assets of a partnership. The partners own the assets jointly. They jointly own those assets. You can agree, and some partner can bring in his favourite desk and say, "This is my desk. I don't want it to be partnership assets." But otherwise, the partnership as a firm owns the assets jointly. A member of a company has no interest in the assets of the company. A member owns shares, and that shareholding gives him a bundle of rights, a collection of rights, but they have no insurable interest in the assets of the company. After assets comes separate entity. A firm doesn't exist as a separate entity, it's just you and me and two others, a collection of individuals, and we don't exist as a separate entity. It does not have a formal identity itself. Whereas company does have separate personality, even though it may be an unlimited company. Doesn't matter if it's public or private, doesn't matter if it's quoted or unquoted, doesn't matter. As a constituted company, it's a company that has gone through the process of creation, of registration or creation. It is a separate legal entity, but partnerships aren't. Transfer of interest. Partners can't transfer. Do you remember my son in the last lecture, the Mohican green hairstyle? Partners can't transfer their interest without unanimous consent. There is an exception. In a limited partnership, under the Limited Partnerships Act of 1907, a limited partner can transfer his interest without unanimous consent. That limited partner can't dissolve the firm by notice, he can't dissolve it by death or insanity, he can't dissolve it by bankruptcy. The limited partner, remember, he can't take part in management either. All he can do is put money in and hope to receive a return on his investment, that's all. But he can transfer his interest. He can say to his Mohican son, he can say, "Look, there's my 30% of this limited partnership that you can enjoy the returns of, but you can't take part in management." Members can transfer their shares without exception, without limitation. You can put the restrictions in a company that restrict, in a private company, that restrict a member's availability to transfer their shares, but unusual. Reduction of capital, very easy for partners, just withdraw their capital. We just agree that we'll withdraw our capital. Partners, easy to withdraw, very difficult for companies. They've got to go through a process of passing a special resolution, getting the consent of the court, and it has to be allowed by the Constitution. So it's jumping through hoops, burning hoops, backwards with a blindfold on, with one leg tied behind your back. For a company to reduce its capital is very awkward. Partnership's dead easy. Active participation. Partners are entitled to take part in management unless we agree differently. If we agree differently, you can't. Members can't take part unless the member happens also to have been appointed as a director. But then they're taking part in their capacity as a director, not in their capacity as a member. Taxation. Partners get taxed on their profit share. Members don't get taxed on the company profits. The company gets taxed. Corporation tax. Members get taxed on the dividends that the company pays out, but not on the profits that the company makes. And finally, secretary. I suppose we could have another one, couldn't we? Secretary, no requirement for partnership firm to have a secretary. Public companies must have a secretary. Private companies don't need one, but public companies must have one. I'm going to add another one in here, and then you can go on and on and on. It's like comparing the number of available hotel rooms in Baku with the average number of apples on a tree in Lithuania. Basically, there's no comparison. You think of anything that relates to a partnership, and it will be different for a company. They're as different as each other as chalk is from cheese. I'll add one more, and that's audit. Partnerships don't have to have an audit. Public companies do. You can have an audit. They may have, if they want one. PLCs must have. Private companies may have. So partnerships are similar to private companies, but they're quite different than public companies who must have an audit. And that's it. That's all I'm doing on this one. And that's the end of partnership. I hope you've enjoyed the partnership. If not, you must be insane. There will be questions on partnership and or agency within the exam. There are so many, 45 questions? And the examiners within these now multiple choice examinations, computer-based examinations, have indicated that they will examine across the syllabus. So there will be a question on partnership, probably. Okay?